may interview before the Honorable Justices of the Supreme Judicial Court, sitting for law court in Portland, within and for the state of Maine. They come forth to declare, and they shall be heard.
Good morning. You can be seated. And the first matter before the court this morning is Androscoggin 24541, State of Maine versus Aaron Aldridge. We are being streamed by audio and video on the web. If counsel would identify yourselves by saying your name for the record together with the party you represent.
The appellant, Aaron Aldrich.
Katie Sibley on behalf of the state.
Thank you. And Attorney Pratt, if you're ready to proceed, we'd be happy to hear your argument.
Thank you, and good morning. Chief Justice Stanfill, members of the court. Aaron Aldrich's ability to receive a fair trial was hampered by the trial court's extensive ruling that allowed prejudicial, irrelevant, and improper evidence before the jury. Mr. Aldrich was also prohibited from the use of beneficial evidence to defend his case.
Mr. Pratt, I note that you didn't actually reserve time and the green light is on. You have identified some, I think, 14 or something evidentiary rulings that you think are erroneous. Which do you think are the strongest ones that you have?
If I were to rank the top three,
Yes.
I would say number one is Brittany Manzo's testimony. And just to remind the court, Ms. Manzo testified that Aaron Aldrich on a previous day had shot a gun at her. That is completely irrelevant to the charges. It is prejudicial. It would cause a jury to think this has happened.
The state indicated that it was offered to show essentially the nature of the relationship, which is always a sort of a catch-all phrase, but more specifically, her fear of him, and so why she may not call the police.
And I would say that the prejudicial effect far outweighed any probative value that that argument would have, because again, the danger here is that the jury says that he had fired a gun at someone in anger before. He could have done it again. I would say that...
Did you request a limiting instruction about that testimony? I understand it was objected to, but then once the court let it in, was there any request for a limiting instruction about how the jury could or could not use it?
Not to my recollection, and I would say, although I was not trial counsel, I would defend trial counsel's position not to do so. My general practice when I'm trial counsel is to largely avoid limiting instructions because I feel like it re-emphasizes the evidence so often. So I don't think that that should cut against trial counsel in this particular scenario.
Isn't the fact that he shot at somebody also relevant to the possession of a firearm charge?
I don't see how it would be weeks prior to it, given that the allegations is that it was possession of the firearm on this particular instance. I know it's on or about, but again, all of the evidence suggested that it was directed towards the double homicide possession of a firearm. If I could return to your question, though, and go to number two, which was that the evidence that Mr. Aldridge wanted to testify that Shoaib Adon, if I say these names incorrectly, I apologize, had made threats to him, and that was deemed not allowed by the trial court. And this was extremely important for the defense, and that was, we believe, as a matter of black letter law, incorrectly ruled, given this case's prior evidence to show the reasonableness of apprehension of danger that Mr. Aldridge faced from Mr. Adon.
And what inference would you have the jury draw if he was able to testify in that way?
That it would put his actions in more reasonable light to act so quickly because...
Of self-defense.
Yes.
But I'm really jumping ahead. You want to stay on that issue, but the photographs that went in showing the positions of the bodies within the structure, I think the state will argue that that would undercut his narrative of how things occurred and where people were when the shooting took place. So with that, if that evidence comes in and has that effect, doesn't that undercut the weight, the importance of him being able to testify as to the victim's previous alleged threats?
If I understand the question correctly.
Yeah, it's a little convoluted, but yes.
Of course, I think it would have I would be disingenuous to say that it wouldn't have some impact. But what is important is I think it would better explain why maybe Mr. Aldridge reacted so quickly, maybe why he doesn't have a clear recollection as to exactly what happened in what position, because he was scared because he'd previously been threatened and everything happened so quickly. I think it just puts it in a better, broader context. And again, we believe it's a matter of black letter law that it should have been.
Counsel, didn't
allowed.
Mr. Aldridge also testify, though, that he had dealt with Shobe before, wasn't that concerned about him, didn't bring a gun to the house because he didn't think he needed to protect himself from Shobe? So I'm having trouble understanding sort of how that testimony would square with his testimony that I knew he threatened someone and I was scared of him.
I think there's really sort of two parts to your question, even though it was asked in one part. And
Fair
if
enough.
I'm wrong, feel free to obviously cut me off. But I think the first question, though, is we should have been allowed in as a matter of law. And the answer, I think, is unequivocally yes. I think a hard yes. Then the second question is, does it contradict or
Is it credible?
is it credible is a different question that should have been left to the jury. And we don't know how they would have, as the court always instructs, you can accept all of the testimony, some of the testimony, you can give more weight to this, more weight to that. We don't know what weight they would have given had they known that he had been previously threatened by this individual. Maybe that would have been enough to save the day.
The testimony wasn't that Mr. Aldridge had been previously threatened, right? I thought it was that a third party told Mr. Aldridge that Shobe had threatened that third party.
My understanding is that a third party had told Mr. Aldridge that he had been threatened by Mr. Shobe.
That Shobe was threatening Aldridge.
But via a third party, if I'm incorrect about that, but that's my understanding.
Wouldn't there be a hearsay problem there, or what?
No, this court's case law, Stanley, Holland, Ketchum, I believe, all have said that hearsay doesn't apply when it's due to someone's own belief that they've been threatened by a party, because it goes to their feeling of apprehension, their desire on how they act. It could be quadruple hearsay and it would still be allowed based on this case.
So what's number 3 in your top 3?
Oh, my number 3 would be the extensive, I would say, over-the-top evidence of what occurred in New Hampshire, which was the arrest of Mr. Aldridge, the stealing of the van, the possession of the gun and the ammunition in New Hampshire, none of which was relevant. And I would say this was the majority of the state's case. I didn't put it into a calculator to find out how much, but by my interpretation, it was more than 50% of their case was about what happened in New Hampshire and his arrest, which we think is utterly irrelevant to the case at hand. I know that the state's going to argue that it talks about flight, but there's a difference between flight and saying that he was a danger while in New Hampshire. They had to shut down the mall. They had to bring in, I believe they had 3 officers from New Hampshire to testify about the arrest, about the gun that he possessed, the firearm, the ammunition. And just to be clear, that gun and ammunition weren't linked to this crime.
I think this, I'm going to anticipate the state, they'll probably say, this wasn't just flight, this was flight on steroids. This was desperate flight by somebody who was armed, knew he was a suspect in a murder, and all of the stealing a van and fleeing from the police at the scene, throwing the gun away, are all under the umbrella of acknowledgement of guilt by flight, but that this was such an over-the-top flight that it justified bringing all of this stuff in as one big picture. They may or may not say that, but I think that would be the rebuttal.
So I would say with respect that the van theft and the New Hampshire arrest occurred days later in a different location. They were not contemporaneous with the shootings. Allowing them in essentially lets the jury convict Mr. Aldridge for being a bad actor, generally, which is exactly what 404 forbids. And that this is too far in both time and action to the murder itself, the alleged murder, or the convicted murders, however you want to phrase it.
I don't think the murder was simply alleged.
Right. So it was too remote in time to be able to be appropriately used.
It was just, as you said, just a couple of days later, right? We're not talking about a year later or something like that. So isn't it wasn't it fair for the state to sort of try to make the argument, as Justice Meade said, that this is someone who's desperately trying to get away from Maine?
Again, I think, though, that then confuses the jury as to what is the important issue here. The
But
important
how do you
issue-
parse it out? I mean, I guess that there is that. I mean, if we agree with the state that certainly evidence of flight is, and trying to escape, both escaping from Maine and frankly trying to escape when they tried to arrest him, if that is admissible, how do you parse out some of the other things?
I think you get into danger when you bring in law enforcement to say he was such a danger, he did X, he did Y, he did Z, as opposed to just saying, we apprehended him in New Hampshire. And that then, while we objected to the flight instruction to, if flight is allowed to be used of consciousness of guilt, to say that that was sufficient to say he was apprehended in New Hampshire, and I think that would be the line would be drawn.
And so all they can say when they apprehend him, because didn't he run at, originally when they got to, was it a mall in New Hampshire?
Mall, yes.
And he ran there too, right?
Yes.
So, I mean, it's not just that he ran from Maine, it's also that he ran from law enforcement.
I think that would be within the bounds of reasonable, as opposed to
And you're saying that's
making-
all they can say? They can't say, and by the way, there were all these other incidents around, what happened, and this is how it happened and how it unfolded.
Well, that's what I'm arguing. I'm hoping that's what you'll say, is that that's where the line is, because it starts to confuse the issue of 404. It allows them to convict for him being a bad guy. I think the state did an excellent job of proving he was a bad guy during the course of this trial. I mean, there's no doubt that he stole the van. There was no doubt that he ran from law enforcement. The question is whether or not the jury convicted him based on 404. And when you spend the majority of your case focusing on these actions that were unrelated to the charged crimes itself, I think that should raise the red flag for the court.
I was surprised that you didn't include the extraditable warrants testimony in your top three.
Well, I would put that as that was actually listed as like a subpart of my three. Was
Okay, well,
the
talk
extra-
about that for a minute. I mean, what is your concern about the fact that he had extraditable warrants in New Hampshire?
I would say the exact same thing I said about the van, the firearm, the ammunition, that is not related to the underlying crimes that are charged here.
Because this was warrants for other offenses.
Yes.
Yeah.
I'm sorry I didn't say that.
But it does explain how and why the New Hampshire authorities were able to move in, to become involved.
But I don't think that's relevant to the trial that's at hand here. Again, I think they should, one officer, not, I think in total from New Hampshire 3, then multiple ones from Maine talking about getting the firearms, getting the ammunition. I think there were 5 or 6 police officers who testified just about the apprehension and bringing him back. Again, that was the majority of the state's case in a double homicide case, was about the apprehension and the evidence surrounding the apprehension.
Well, the firearm and ammunition, though, doesn't that go to the separate charge of possession of a firearm?
Again, my understanding is that the firearm alleged was the firearm related to the one used in the homicide, not into the firearms afterwards, because that would have been a charge only in New Hampshire.
Didn't he
not
have the
in Maine.
handgun with him when they arrested him?
Right, but again, that would have been a charge in New Hampshire, not a charge here in Maine that he would have been able to be convicted of under this.
But he took the firearm from the scene, right?
He took a firearm, not the one that was recovered from him in New Hampshire.
Wasn't the
Oh, I thought it was
ammunition,
the
though,
same.
that was found similar to the ammunition that was utilized in Maine in connection with the murder?
I didn't think it was, but I can double check that. I apologize. I don't have that fact at my fingertip. Unfortunately, the red light's on. I didn't want to end with
It is, but
conceding a point.
we recognize that it's there are a lot of issues in this case. So
Thank you.
I'm going to invite my colleagues if anybody else had additional questions. Okay, thank you. Attorney Sibley?
Thank you, Chief Justice Stanfill, and may it please the court. On the night of February 20th, 2023, Aaron Aldrich shot Shoa Badan and Muhammad Aden multiple times, killing both of them. Mr. Aldrich committed murder for 2 reasons. He wanted money, and he couldn't leave any witnesses. After taking what money he could find and a Glock handgun, and with his sneakers and jeans splattered in Shoaib's blood, Mr. Aldrich fled the murder scene and then the state of Maine. At trial, Mr. Aldrich testified that he killed Shoaib and Muhammad, two men half his age and half his size, in self-defense. The jury resoundingly rejected his testimony. Here, the trial court did not err in its evidentiary rulings. Much of the evidence he asserts as error was directly relevant to the state's burden to disprove Mr. Aldrich's self-defense claim beyond a reasonable doubt, probative of his state of mind, his intent, and his consciousness of guilt, and demonstrated that his testimony was inconsistent with much, if not all, of the physical evidence. Given the overwhelming evidence of Mr. Aldrich's guilt, any perceived error in the trial court's rulings was harmless. The trial court also committed no error in its jury instructions. The evidence more than supported instructing the jury on flight as consciousness of guilt, and the instruction as given was nearly identical to the one that the law court approved of in State versus Hassan. Conversely, the evidence did not support an instruction on necessity as a defense to the charge of possessing a firearm by a prohibited person. By his own testimony, that he continued to possess the Glock well beyond the time of his asserted danger, Mr. Aldrich himself negated necessity as a viable defense. Finally, the trial court committed no obvious error when imposing Mr. Aldrich's sentences. The court's findings are clearly supported by the record, and given the presence of two gateway factors to a life sentence, premeditation in fact, and his intent to commit multiple deaths, it was well within the trial court's significant discretion to conclude that no mitigating factors asserted by Mr. Aldrich meaningfully impacted the base sentence of life. For these reasons, and the ones articulated in the state's brief, this court should affirm Mr. Aldrich's judgment of convictions and sentence, and I'm happy to take questions at this time.
Then let's go straight to some of the issues, evidentiary issues, that Attorney Pratt has indicated. First, you agree that if there is, when someone is asserting a self-defense in a case, that if there is evidence that a victim has allegedly threatened the defendant, that should come in?
In general, yes, Your Honor. I
So
believe.
why not in this case?
Well, this case is far different than some of the other ones, say Eliot. Here, it was an unspecified threat to an unspecified associate at an unspecified time. And with all due respect to my friend, Attorney Pratt, my reading of the record was not that this other unnamed associate that Mr. Aldrich was threatened, it was the unnamed associate.
So you're just saying it was essentially too tenuous and not credible. I mean, isn't that really a jury question, whether it's a credible threat?
In some ways, yes, Your Honor, but this had no specifics whatsoever. And so given the absolute lack of specificity, the real thrust of this evidence was to say, well, the victim was a bad guy and threatened made an unknown threat to one of my unnamed friends at an unknown time, so therefore my apprehension of danger was reasonable, just far too tenuous.
But do you agree, counsel, that I think the court excluded it on hearsay grounds. Do you think that was a correct ruling?
Well, given some of the court's earlier questions, that could potentially be questionable, but importantly, even if this was error, ultimately it was harmless because there was other evidence from which the jury could have drawn that conclusion. There was a state's witness who testified that it was either the day before February 20th or that day had seen firearms in that residence. Mr. Aldrich had also testified that within, I believe it was February 18th, that Muhammad, Mr. Aden, had pointed a firearm at him in that residence. So there was evidence where the jury could have found that his apprehension of danger was reasonable. They rejected that.
Let's go to the extensive evidence of prior bad acts that came in this case. And I understand that prior bad acts can come in or bad acts can come in for a lot of reasons. But we've got evidence of that there's extraditable warrants, so he's been charged with other crimes. The jury gets to know that, in addition to that he had crimes before, essentially, this occurred, that he was charged with. The jury gets told that he stole a van from Lowe's in Brunswick. They get told that he's, armed and dangerous and a really scary guy when they're trying to round him up in New Hampshire, and there's a lot of time was spent on all of this. Why is Mr. Pratt not correct that this was essentially, let's convict him? He admits the shooting, so that part isn't really an issue, but he claims that it was self-defense, putting aside the credibility of that argument in other respects by showing what a bad guy he is and that he has lots of other crimes and he's, armed and dangerous and really scary. Isn't that a problem?
No, Your Honor, for multiple reasons. To look at the 50,000-foot view, the state has the burden to disprove self-defense beyond a reasonable doubt. And most of this evidence wasn't prior, but it's conduct after the murders happened. In a general sense, this evidence shows that all of this conduct was inconsistent with somebody who has acted in self-defense.
How?
It helped.
How does stealing a van show that it's inconsistent with self-defense?
Well, as Justice Meade had described it, and wasn't a phrase I was going to use, but I liked it, this was flight on steroids. It helped show his modus operandi. He takes and uses firearms to commit crimes. He admitted.
What about the testimony from Brittany Manzo that he shot at her before?
So that Your Honor, goes to, again, the 50,000-foot view, for the jury evaluating her credibility. There was significant evidence that really painted her in the light of an accessory after the fact. Mr. Aldrich provided testimony as to why, I don't want to say that she would lie, but why she would testify in certain ways. So this evidence was directly relevant to her state of mind and provided context for the remainder of her testimony. It would have been well within the jury's discretion to say, nope, you're not credible, I'm going to push this out. And maybe they did and decided Mr. Aldrich's guilt on the far more compelling evidence, which was mostly physical, the positioning of the bodies, where their wounds had been sustained, the fact that Muhammad was laying on the floor where Mr. Aldrich apparently said that he had shot him from, the DNA evidence from the blood on Mr. Aldrich's clothes and sneakers, and the fact that he admitted to 3 different people that he had shot these individuals with no mention that it was done in self-defense.
Counsel, just going back to what happened in New Hampshire, I understand the argument that flight was important and relevant to the state's case here, but as Attorney Pratt has said, that could have been sanitized somewhat. It could have been, yes, he fled to New Hampshire, he ran fast, he ran out of his shoes, but why all of the detailed testimony about what was essentially a SWAT takedown? I mean, there was just a lot of information from the New Hampshire officers about their tactics and plans to isolate him. How was any of that relevant? Or even if it was slightly relevant, doesn't that sort of tip the balance into prejudice?
It doesn't, Your Honor. Again, it's all relevant to and directly points to not only Mr. Aldrich's modus operandi. He takes guns, he flees from law enforcement, but as well as disproving self-defense in the sense that, is it reasonable that a person who acts in self-defense then steals a firearm, buys more ammunition, flees the state of Maine, flees from law enforcement officers before disposing of that gun?
How about sure, if they think I'm a bad guy because I've got these warrants and everything else, so nobody's going to believe me?
Well, the jury was not told any specifics about the warrants.
They were told that he had warrants for his arrest out, pre-existing the murder charge.
And And that was to explain the context of how, it was to explain two things. One, the context of how the Maine State Police end up in New Hampshire, and to explain why Mr. Aldrich was taken into custody, because I believe, if I remember correctly, part of the opening was painting this investigation as a rush to judgment. And so it was to clear up any confusion that in New Hampshire, Mr. Aldrich was not, he was not in custody for the murder. He was not arrested for these murders. There wasn't even a warrant. There was a separate reason that he was in custody. The state police were down there to bring him back and to have the opportunity to speak to him.
Just can you refresh my recollection? Was the gun that he had at the scene in New Hampshire, was that the one he had taken from the residence or one he procured separate from that? Did you follow?
He had a handgun.
He had a handgun?
Yes, so there were...
What was it? How did he get that? Where's that handgun from?
So the Glock handgun is from the trailer. Mr. Aldrich
Okay.
himself testified that he took that Glock handgun from the murder scene. That remained in his possession until he discarded it in New Hampshire.
Okay, I thought I heard you say he bought or you procured a gun in the meantime, but you're just talking about the fact he took the Glock and then
And
the
ammo from Cabela's, right?
Yes.
The ammunition was 9mm, which would be consistent with the Glock that he had in his possession?
Correct, as well as
Okay.
what the state alleged was the murder weapon,
Okay,
the ballistics.
I thought you meant he acquired one separately.
No, you're,
Okay.
But
if I
just to
said that,
finish the
I
point, the
misspoke.
ammunition he had was consistent with the ammunition utilized in the firearm that was, by which he perpetrated.
Yes, I mean, he specifically bought magazines and ammunition to match the gun that he took from the murder scene.
Which was not the murder weapon. It was a different gun.
Correct. The ballistics testing did rule out the Glock as the firearm. The ballistics testing couldn't definitively say that the high point 9mm was the murder weapon, but that it was very likely the murder weapon.
What about in sentencing? I guess we're talking about that also here today. For a judge to say, there's no mitigating factors. I'm not going to accept any mitigating factors here, just slamming the door on that. Is that problematic?
Well, I don't believe that's exactly what the trial court did here. I don't remember if the word used by the trial court was significantly or meaningfully, but the court did acknowledge the mitigating factors and simply said, yes, these are here, but it doesn't impact the ultimate outcome because of the significant objective evidence of premeditation and intent to cause multiple deaths, either of which by themselves can justify the imposition of a base life sentence. If there are no other questions, I'll sit down with Your Honor's permission.
There don't seem to be other questions. Attorney Pratt, when we go to the over-the-top SWAT offense or response in New Hampshire, I mean, even though he wasn't charged at that point, there was no warrant for the murder, I mean, there's no question he was a suspect in the murder. I mean, isn't that enough in and of itself? In other words, he's suspected at that point of murder of two people with firearms. Isn't that enough to explain the SWAT response in any event?
I don't think it's necessary to explain any of that to the jury except to say that he was taken into custody in New Hampshire and that he was fleeing the area. I would just like to emphasize, while Justice Meade and Attorney Sibley described it as, flight on steroids, I would say that it was the testimony on steroids. I mean, it wasn't just that he was armed and dangerous, it was the potential need for a tactical takedown. Testimony about contingency planning for hostage or active shooter, that they were afraid he may be an active shooter at the mall, and so that's why they had to take these additional steps. Not just that he was a suspect in a murder, but that he may open fire in New Hampshire. I mean, this is one bad guy who could have opened fire at the mall in New Hampshire.
But they knew he was armed, knew he had a Glock, and allegedly had used a gun before on a person. Why shouldn't they have a high-profile response?
Well, again, because I'm not saying they shouldn't have a high-profile response. What I'm saying is it shouldn't be allowed to come in front of the jury to influence the jury's decision.
Counsel, can I just ask a clarifying question? Do you contend that any of these errors you've identified, suppose we find error, that any of them alone would suffice to vacate the conviction, or are you resting on the cumulative error
I think
principle?
the cumulative error is the strongest of the arguments because there are so many errors in our opinion. I think there were 11 plus, maybe with some subsections, but I would say that the argument that on its own may be sufficient would be the exclusion of the threat that was directed at Mr. Aldridge.
What was the evidence going to be of the threat?
Mr. Aldridge's testimony,
That somebody else told him, that somebody told that person?
which according to this court is perfectly allowed.
I understand why it's not hearsay.
Yes.
May I
Thank
have
you.
leave just to follow up?
Yes, absolutely.
Was the threat that he heard about a threat against him or against his unnamed associate?
I don't think it's relevant because either one it would be allowed in according to this court's rulings, that as
Okay.
long as they had a propensity towards violence, that reputation would be allowed in the calculation. My memory was that it was directed at Mr. Aldridge. Ms. Sibley's is that it was directed at the third party. I apologize for, there were a lot of facts and I was trying to memorize them all, so I apologize. But either way, I don't think it's relevant for the court's
Right,
analysis.
I was just curious.
There were a lot of facts, hence some of the questions to you are on the facts.
Yes. Thank you very much.
Thank you, counsel. Thank you for your argument here this morning, and as is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. With that, we'll be in recess on this case.
All rise.
Good morning, you can be seated. The matter before the court this morning is Richard Tappen et al. Versus Clark Hill et al., BCD 24539. I see counsel are present. We are being streamed on the web, both by audio and by video. If counsel who are arguing would introduce themselves together with the parties they represent, starting with the appellant.
Good morning. Glenn Israel from Bernstein Shore for the appellants.
Good morning, Your Honor. Benjamin Ford for the appellees, the Hill family.
Thank you. And Attorney Israel, if you're ready to proceed, we'd be happy to hear your arguments.
Thank you, Your Honor. So I've reserved 3 minutes, and I'm going to go fast, so hopefully I won't go
3
too
minutes is
fast.
3 minutes, no matter how fast you go.
So the Tappen's appeal in this matter is based upon the trial court's misapplication of the burden of proof. Both the existence of a recreational easement and the location of the recreational easement were raised by the Hills as affirmative defenses and counterclaims. Thus, they had the burden of proof on both of those issues. But the court found on the existence of the easement that there must be a recreational easement because it couldn't infer from the record that there was an intent to limit the use of the beach. That placed the burden on the Tappens to prove that there was no easement, and that's the wrong result. The Hills had the burden of proof. They failed to produce any evidence of a recreational easement other than the label Seawall Beach on the plan. The court determined that label alone was not dispositive, but then went on to find in favor of the Hills by saying that there's no evidence of an intent to limit the use of the beach. That was an error of law. Similarly, the Hills had the burden to prove the location of their purported easement, and they failed to do that. The trial court should have ruled that absent evidence to the contrary, when a subdivision plan refers to a beach in the state of Maine, it means the area between the high tide and the low tide mark, a settled legal definition in the state since the 1800s. Instead, the trial court ruled that because neither party could prove the precise location of the upland boundary of Seawall Beach on the face of the earth, it couldn't rule on that issue. That, too, was an error of law. The Hills had the burden to prove that the developer intended to create an easement on something called Seawall Beach that's different than every other beach in the state of Maine, and they didn't prove that. Pursuant to Almeida, absent such proof, the court was bound by legal precedent to declare that Seawall Beach is the area between the high tide and the low tide line, like every other beach in the state. As a ministerial matter, I've prepared a color-coded blow-up of pages 81 and 82 of the appendix, and I have some smaller versions of that if the court would like to take them back. The yellow
We
lots
have
are...
the actual exhibits that were admitted,
I understand that, but what I did here for the court's convenience, because I know I can't read the little print,
None of us
I
can
colored the
either.
Tappens lots yellow, I colored the Hill Cottage Corp lot pink, I put an orange circle around the place where the lots of the individual defendants are located, and I underlined in red the various labels because they're very hard to find.
So did we. To the
So
best
did
of our-
you.
Hopefully they line up with what you did.
Okay, mine are slightly bigger, and they're here for reference by both sides. So I'm happy to answer any questions that you have at this point.
So I'm curious about this argument that you are making, that the burden of proof, that the court said it couldn't have on the easement, and we're talking about the easement to use the beach, correct?
Well, I guess it's the scope of the easement that's in question. The colonial ordinance says everybody gets to use the beach for fishing, fouling, and navigation. The court found that there was a recreational easement that's broader than that.
Correct. And that's what we're talking about. When you said that the burden of proof, that the court essentially by saying you couldn't infer that the developer had planned to limit anything, flipped the burden of proof.
Yes.
Did I understand your argument?
Yes.
And I just don't see that in the opinion. What he says is that the court concludes that all of the residents of the subdivision depicted in the 1893 and 2022 plans enjoy an implied easement to use Seawall Beach for recreational purposes consistent with beach use, and reaches the conclusion after review of the plan itself. The clear intent of the developer was to develop a set of vacation homes, et cetera. So I don't understand how that flips the burden of proof.
Well, what you just read, Your Honor, was the conclusion, the ruling.
Yes.
The logic for the ruling is in the paragraph before that, where the court says, the only evidence I have is the plan itself, and I can't
But
infer
that's for the
from...
triangular portion, it says. The only real evidence the court has of the developer's intent with respect to the triangular portion is the map itself.
Okay, and the court didn't put in its findings of fact, of which there were 50, any other facts to support the finding that there's a recreational easement. The Hills have proposed that there are some photographs that are of people on the beach that support that conclusion. Those photographs are from the early 1900s.
Why isn't it sufficient to infer a recreational easement from the plans themselves, which show a large beach and call it's beach estates?
Frankly, it probably would be okay for the court to infer that. But what the court specifically said was, I can't infer that there's a limit. And because I can't infer that there's a limit, because Tappen hasn't given me any proof that there's a limit,
I guess that's what
I'm going to infer
where
that
does
there's
it
no
say
limit.
that? Where does the decision say that?
That I can't infer that there's a limit? It's in the paragraph right before the sentence that you read. I can't infer that the developer intended to limit the use to fishing, fouling, and navigating.
But that was the triangular portion.
That would be page 11 of the judgment, appendix at 19.
All right, well, move on. I don't see it, but move on.
Well, I mean, I think it's a critical point, right? If all the court has to say is, I looked at the plan and I think the plan indicates a recreational easement, then I guess my argument against that is that that's insufficient. You know, the court can't just say, it says beach, so there must be an easement there. And that goes to the argument.
Didn't we essentially say that in Arnold versus Boulay?
No. In Arnold, the area at issue was a road.
Well,
And
the
and
area
it said-
issue was called a road,
It
but
was
that's
called a-
not what they were using it
Well, but
as.
if you look at the historical interpretation of plans in this court and elsewhere, when a developer says road, that expresses all by itself a clear intention. This is a road, it's for use by the members of the subdivision.
So if
When
I
a de-
understand what you're saying is, despite the fact that that's not how they were using it in Boulay, and in fact, we noted that with respect to it, there exists an by implication, an easement in Lakeshore Road to the full extent entitled to enjoy it, free from obstruction. But we cited a New Jersey case that talked about whenever the owner of a tract of land lays out into blocks and lots upon a map, which is what happened here, and on that map designates certain portions of the land to be used as streets, parks, squares, or in other modes of a general nature calculated to give additional value to the lots delineated thereon. I mean, isn't that exactly what the trial judge here found happened?
Well, the trial judge didn't explain that that's what the trial judge found happened, but I would say if that is what the trial judge did, it was incorrect. So
Why?
we've long presumed, the courts have long presumed, that a road is always dedicated just by merely being called a road. Any other feature needs to be clearly dedicated as a, let me call it public, just for lack of a better word, feature. So a park is clearly for public use. If you look at the cases that are cited in both briefs, all those cases from out of state have lots and lots of evidence of a dedication for public use. In the Arnold case, there was a road that was too wide to be a road, and part of it was on the lake. And so the court said, okay, clearly that thing is dedicated for public use because it's called a road, but they can use it for other things also because it's indicated from the plan by the fact that it's 90 feet wide, there's room there to do other things. Here,
Can we just go back to the analytical flow here to see if I'm on the right page for what you're talking about?
I was about to get there, so let me finish my sentence, and then you can see if I did it or not.
Okay.
So here, what we have is the court saying, this thing says beach. And since in 1893, everyone had a right to go fishing, fouling, and navigating, and I can't find anything on here that says beach only for fishing, fouling, and navigating, I'm going to assume that the mere labeling of this thing as a beach is an intent to create a quasi-public easement here. But we don't have to assume the same thing on this plan with respect to Silver Lake or Woods or Grove. And the Hills point out, well, this isn't called the Silver Lake Estates, it's called Popham Beach Estates. But I would point out that this is Seawall Beach. And
I was actually
there's
going
nothing
to a
on here
slightly
called
different
Popham Beach.
analytical flow here. Just correct me if I'm wrong. I think in the past we've relied upon developers' perceived intent based upon the subdivision plan, to conclude that easements existed in other contexts. So here we have a couple of plans that designated Seawell Beach, Riverside Beach, and those areas would not be divided into lots for purchase. Am I okay so far?
Correct.
Okay. So wouldn't the manner in which the lots were conveyed supports the claim that there was, in fact, an implied easement over the Seawell Beach portions because it was set aside and that these were beachfront properties or beach access properties?
Yes, I agree.
Okay.
The question is the scope of the easement. In 1893, the mere fact that there were roads in the subdivision that went to the beach does not necessarily imply a right to sit on the beach, play volleyball
Well,
on
we
the
can
beach.
agree that it doesn't necessarily imply, but the question is when the judge inferred that it did imply that easement, is that error?
If the judge had done that, I would be arguing that it was error, but it was certainly error for the judge to say, I can't infer the negative, therefore I'm going to go the other way. I mean, I guess that implies that he did infer the positive, but he never did say that. But we're spending a lot of time on this argument. I'd like to get to the next one.
Okay, well, that's the way I read it, but I guess we'll have to-
I mean, I
let's
don't know
go
if
to
the court has
next
questions
argument.
about the other one, but to me, that's the more interesting argument, is the location. I think beach is beach is beach in the state of Maine.
Except that, in this case, it looks like, if you look at the release deed, Exhibit 6, with the A attachment, so I'm looking at the appendix on 83, 84, so the picture of Exhibit A that was attached to the release deed
Yes.
clearly draws, and there's no other description of the land, it just says by reference to Exhibit A, clearly draws a boundary well above the high tide line.
And that area between the dotted line, which is the high tide line, and that's always been in dispute, which is why this is a release deed. Our expert testified that area was supposed to be part of the lots. The court didn't accept that testimony. The other side didn't have an expert, but
Why can't the court just say, I'm not sure exactly where on the face of the earth the edge of the beach is, the dry sand portion of the edge of the beach is, but it's higher than the high tide line? I mean,
because
essentially, that's what he said.
there's absolutely no evidence to support that. And the court didn't say that. The court said, I don't know, so I'm not going to decide. There's no evidence that it's anywhere other than the high tide line. The burden of proof was on the hills. Now,
Wait, isn't Exhibit A evidence in and of itself that it's somewhere other than the high tide line?
This was a release deed. This is to the extent I own this. So what you can take from Exhibit A is that with regard to lot 205 anyway, Tappen owns from Honeywell Avenue all the way to low water, regardless of where that line is. He's got a deed that says I own lot 205, and he's got a release deed that says I own everything between lot 205, wherever that may be, and low tide.
Right.
And so he certainly owns that entire thing. So whether he has standing or not to bring this case, that's well settled. But the court didn't have to decide who owns what to get to, which is why the court wanted to add TAPCO, because it was concerned about that fact. It didn't have to add TAPCO. In fact, Hill argued that it didn't have to add TAPCO. Hill said, I have an easement. My easement is here. And then they didn't prove it.
Thank you.
So their easement is to a beach, and a beach is between high tide and low tide, and the court erred when it said it could be somewhere else.
Thank you, counsel.
Thank you.
Attorney Ford?
Good morning, Your Honors. Attorney Ford for the appellees, the Hill family. May it please the court. So to respond to some of these issues, I'm going to make a couple of different points. To the first argument, to the extent that the appellants think that there's an insufficiency or that the judge in the lower court was inconsistent with its opinion, there is a remedy for that. It's Rule 52B. Appellants could have made a Rule 52B motion to get clarity or for further findings of fact. Because they didn't do that, that further makes the standard of review here even more deferential because it's not a matter of whether or not there was clear error. It's a matter of if we assume the lower court found the facts necessary, is there anything in the record that can justify that conclusion? And in fact, there is plenty of evidence justifying the lower court's conclusions here. As to the second argument with respect to the boundary, the location of the boundary is a question of fact. It's not a question of law. That question of fact is reversible only for a showing of clear error. And the court was frankly well within its discretion under the Markley case to decide that it cannot, or that the evidence before it did not justify a finding of the location of the boundary on the face of the earth. So let me go back to my first arguments as to the first point. The appellant here is arguing that the facts found by the court do not justify the result reached by the court. In other words, the facts in the opinion are insufficient to support its ruling. And Rule 52B speaks to this. They needed to file a Rule 52B motion. Rule 52B is there for this exact reason. The lower court is supposed to have an opportunity to clear up any ambiguities that the parties feel it has in the order. And having not filed that motion, this court is left to then assume that the lower court found the facts necessary to reach the conclusion. So having not filed that motion, we have both clear error on the factual finding with respect to the existence of the implied easement, and we also have the assumption that the court had all the facts before it. And in fact, there is plenty of evidence to support the court's conclusion of a finding of an implied easement. The court spent a lot of its time talking about the plans that are before you here today, the 1893 plan and the 1922 plan. And the court looked at those plans, and there's many things listed on those plans, including the very fact that Your Honor mentioned. This is called the Tappen Beach Estates. It is definitely shown that access to this beach was critical as part of the plan. It is true that though the court focused on the plans themselves, the court also had before it all kinds of other evidence to show that the intent of the developers was to provide access to the beach for recreational purposes.
Counsel, I see that the green light is on. Can I return to the issue about the Rule 52B findings? Yes, if there's no motion, we assume that the judge found facts that were necessary to support the decision. However, I think what Attorney Israel is arguing is when the judge says there isn't any evidence or that I can't infer, you still take what the judge said at face value. We don't now say, well, yes, but there really was. I mean, in other words, Rule 52B would deal with absence of facts that are recited in the judgment, but it doesn't insulate what the judge actually did find or didn't find.
I agree, but talking about what the judge found or couldn't find or what the judge can infer or can infer, the language that you brought up in the last argument actually falls right in the middle of the paragraph. It says, the plan's road network is clearly designed to provide all residents with access to the beach. The court cannot infer that the developer's plan was to limit the residents' use to fishing, fouling, and navigation below the high tide line. This is in response to an argument that was made at the lower court. The argument from the plaintiff's side was, well, the reason why these roads exist was to provide the residents of this development access to the beach, but it was only for fishing, fouling, and navigation. It wasn't for general recreational easement. And what the judge is referring to here is a response to that argument, not that, oh, there's a lack of evidence showing one thing or another. In fact, there is a bunch of evidence showing that, or plenty of evidence showing that the purpose for this development was for recreational purposes. And it includes what we refer to as Exhibit 31, which shows a picture contemporaneous with this development of people sitting around the beach in what they called bikinis back then, which were very different than bikinis look now. But the point of the matter being that they were clearly there to swim. They weren't there to hunt birds, they weren't there to fish, and they weren't there to navigate from one point to the other.
I think what the plaintiffs are arguing is that even if one agrees that there was an intent to provide access that can be inferred from the plans, that there is nothing on the plans that would allow you to infer that that access was for purposes beyond fishing, fouling, and navigation.
And that's, of course, a conclusion that we disagree with, as evident by the plan
But what they're
itself.
saying is the judge is saying, yeah, there's no evidence. So, so what did the judge base it on?
I think what the judge is saying here is that he cannot infer that the plan was limited to fishing, fouling, and navigation. In other words, the judge is looking at the plan, and because we make the presumption, and because we're under a clear error standard of review here, we look at this plan and say there is a lot of evidence here to show that recreational use of the beach was being done contemporaneous with this plan. In other words, what Boulay instructs is that we put ourselves in the position of someone buying this property in either the 1890s or the 1920s, and ask, what were they induced? Were they induced to buy that property with the promise of being able to use this property recreationally? And there's all kinds of things on this plan that do that. One is, it's called Popham Beach Hotel and Estates. It's also later changed its name to Popham Beach Estates, not Popham Woods Estates, not Silver Lake Estates. But also in the 1890 plan, there's the Rock Ledge Hotel. There's a path that this is where the blow-ups are helpful, by the way. There's a path that leads from the Rock Ledge Hotel down to a bathhouse. You don't need bathhouses for hunting. You don't need bathhouses for navigation. So people back then had the intent to purchase this land for the purposes of using the beach for recreational purposes.
Or at least that's how the beach was being used. I think it's a little hard to speak to what purchaser's intent was, but.
Purchaser's intent, perhaps, but I think the developer's intent is really, what the issue is here. Because remember, in Boulay, citing the other New Jersey cases, the question is one of really almost estoppel or inducement. If you're going to show something on your plan that would induce somebody to purchase it, then that plan or those benefits are considered reserved for those purposes, and that's exactly what we have here. Now, I will spend some time also talking about this second argument. This is a factual determination. The location on the boundary of the earth, the location on the earth of a boundary is a factual determination. The Markley case gives the court the authority and the discretion to say there is not enough evidence here for me to determine where this boundary is located.
Can I stop you there for a minute? I mean, do you agree with what I gave as essentially a paraphrase of my understanding of what the court ruled, which is I don't know exactly where on the face of the earth it is, but it's somewhere further up the beach than the high tide line?
I would like to, but in all honesty and candor, I don't know that I can agree to that. We certainly think that the location of the boundary is actually at the dune line, and we provided the court with some legal reasoning for that. The concept of an ambulatory boundary or an ambulatory marker is not well founded in Maine law, and the court was, I think, justified in not acknowledging that. And so that's why we didn't file a cross appeal, because it was a long shot to begin with. It's something that we should probably consider in the future, because not being able to locate a boundary can present a lot of problems. There's actually, in the Markley case, it has a very, very interesting concurrence. It talks about the preclusive nature of that decision and the fact that, hey, these people can always sue each other again, which is, of course, something that nobody wants. And so I think that, the judge in the lower court.
What we all hope is that everybody gets together and exchanges a mutual.
Yeah, exactly.
We're going to agree that this is where it is based on what's already been litigated.
Yeah, that's exactly right. And let's hope it comes to that. Let's hope we're not up here again anytime soon. But the reality is sometimes we need positions to be determined. In this case, it could not have been determined, and so we're sort of left wondering where that is. And as you mentioned, it really is up to the parties to decide here how they're going to get along going forward, unless they can't. So the other thing that I wanted to mention is that this case had a really interesting trial in that we had a very respected title attorney take the stand and make what is essentially a present factual testimony in the form of a legal argument. And what he said was that beach, if the word beach appears anywhere in the deed and presumably anywhere in the plan, then that has to mean the intertidal land. the judge in the lower court was right to completely disregard that argument just because it's flatly contradicted in Almeter itself, which is the case that the expert relied upon to make that argument. What Almeter said is, yes, okay, if the deed says beach, then we assume high tide line, low tide line, that's the context in which that word is used. But Goose Rocks Beach means something completely different, as does Seawall Beach. So if you said, I'm going to Old Orchard Beach, you're not thinking, oh, this person's going to go sit between the high tide line and low tide line in Saco Bay. They're using that word in context. And that's what the judge hung its opinion on in this case, and not being able to credit that testimony, and I think it was justified. Just because it says beach in this case, it doesn't mean you get the high tide line and the low tide line. Now, there are other contradictory arguments that were also being made, all of which were being made by the appellants in this case. When the appellants started their trial, they put up the surveyor, and the survey testified that there are, at least according to the surveyor, 3 different ways that you could find the property line on this beach, the upland property line. He said you could either find it with what they called the scaled boundary, where you took the tiny little lines and scaled them according to the scale on the plan and then established that. That would put the line somewhere between the high water mark and the dune line. You could look at the plan and say, well, it says sand dunes right there, so it must not mean it must mean the boundary between the sand dunes and the beach. That's the second argument. And the third argument was the high tide line. I think the court was right to point out that Exhibit A illustrates this beautifully. Yes, this is a release deed, but it also shows multiple locations for where that boundary can exist. And in fact, the survey that was presented by appellant's own expert witness said, I don't know where the boundary is. It could be any one of these 3 different places. So the argument that the boundary is located just on the high tide line because the plan says the word beach doesn't really go anywhere, and I think the judge was very right to discount that argument. Unfortunately, he didn't buy our ambulatory argument either, which is the way it goes sometimes. If there are no further questions?
There don't appear to be.
Okay, thank you, Your Honors.
Thank you. And Attorney Israel, I understand you reserved some time for rebuttal.
Yes, I did. Thank you. Am I live? There we go. I have 4 points. First of all, Attorney Ford kept talking about the boundary, the boundary, the boundary. The issue here is not the boundary. The issue is there's an affirmative defense that says I have an easement over the land that you own, and they have to prove where that easement exists, and they couldn't. And so the next question is, Attorney Ford says, well, Almeter says that it doesn't always have to be between high side and low side. And I would recommend to the court that they read that decision very carefully. What that decision says is that if there is evidence of an intent to mean something other than between high tide and low tide, we'll go with that evidence. But without that evidence, the law says between high tide and low tide. And that is what I think the court should have done in this case. In Almeter, there was a very respected surveyor who went into the deed research back to the Native Americans and determined that the city or the town owned some beach or some land above the beach. That's not present here. There was no proof of anyone's intent to refer to anything as beach other than the actual beach. Another point I'd like to address is that Attorney Ford said there's plenty of evidence in the record other than the plan to show the intent of the developer. He points to the photographs, Exhibit 31, I think it was. Those all postdate the 1893 plan. And the testimony by his own client and written in the red brief is that the recreational use has been made of the beach for nearly 100 years. That doesn't get you back to 1893. And then his clients testified, the Hills testified in court, that they could recall use of the beach back to the 1950s. That doesn't get you back to 1893 either. And my final point is, again, Attorney Ford argued that this is called Popham Beach Estates, and so, of course, you've got to be able to use the beach. I would point out that it's not called Popham Dunes Estates. So if that argument works, and you can use the beach, that does not include the dunes. Happy to answer any questions.
Why no 52B motion?
I'm sorry?
Why no 52B motion?
Why no 52B motion? Because the court was very clear, as Justice Stanfield pointed out, that they relied upon certain evidence and they reached certain conclusions, and I didn't see any other evidence that I think they should have considered, so there was no reason for a 52B motion. 52B says you can file a motion if you want more findings of fact or conclusions of law, but you don't have to, and I didn't see any reason to.
There don't appear to be additional questions. Thank you.
Thank you. If the court would like these slightly enlarged, color-coded versions, I'd be happy to.
No, I think we're okay. I think we have all of the blown-up exhibits, as I've indicated, so.
Okay.
It was a little bit of a challenge to start by reading just briefs in the opinion to figure it out, but I think we all did. All right, thank you. We will be taking the matter under advisement, and we'll issue a written decision in due course. And with that, we're in recess on this matter.
All rise.
Good morning, you can be seated. The matter before the court is Washington County, 24-231, State of Maine versus Kailie Brackett. I see counsel are present. I'm assuming ready to proceed. We are being streamed for this argument on the web, both by audio and video. Counsel, if you would identify yourselves by saying your names for the record together with the party you represent, starting with the appellant.
Good morning, Your Honor. Michelle King for Kailie Brackett.
And Katie Sibley for the state, Your Honor.
Thank you. And Attorney King, if you're ready to proceed, we'd be happy to hear your argument this morning.
Good morning, and may it please the court. Michelle King again for Kailie Brackett. Junk science, prejudicial evidence, misstated evidence, lack of evidence, wrongful conviction. The trial court abused its discretion when it admitted the testimony of Dr. Nuremberg because it lacked scientific basis, no other expert attested to its reliability, and several of the tendered studies were not based on similar facts. The 2009 National Academy of Sciences report was a wake-up call to prosecutors, judges, and even defense attorneys as to what evidence should be admitted at trial under the guise of science. OSAC was an agency that was created as a result of this report. It's tasked with setting the industry standards for testing and examination of forensic sciences in an effort to eliminate testimony on junk science. OSAC does not recognize forensic podiatry as a forensic science, in large part because it's never been subjected to black box studies. The International Association for Identification also does not recognize forensic podiatry as an accepted science. The judge's factual finding on this front was an error. Here, Dr. Nuremberg testified that his opinion was subjective. Any two examiners could come up with a different conclusion, he said. That's not science-based. Dr. Nuremberg's opinion that there was a moderate level of support that Kailie made the sock print in question was so low because there were so many variables that he couldn't account for, and there were multiple margins of error. That's not science-based. Dr. Nuremberg himself could not define what moderate meant. He said it was unclear to him what moderate means. He said his opinion was not based on numerical data or statistical calculation, and that he didn't employ the industry standard real method in arriving at his conclusion. The European network scale that he did use, which issues best practices and guidelines for forensics, does not issue any such guidelines for forensic podiatry. Again, not science-based. Dr. McCarthy testified that podiatry is unreliable. Forensic podiatry is unreliable. All of the problems with forensic podiatry and Dr. Nuremberg's opinion that Dr. McCarthy raised go to the reliability prong under the Williams test, yet the lower court addressed them as they go to the weight. This is a clear abuse of discretion. Two studies that Dr. Nuremberg relied upon, whose statistics he cited for the individuality of footprints, talk about bare footprints, full footprints. In this case, we're talking about sock-clad partial footprints. And most, if not all of those studies didn't use the industry method, the real method.
I see that the green light is on. Can I clarify, just starting at the beginning, are you suggesting that an expert in forensic podiatry should be excluded categorically, i.e. not ever, or just based in this case because of some of the weaknesses that you've identified, like the fact that we were not talking barefoot, we were talking sock-clad, blood-soaked, et cetera?
At this point in time, I would suggest, Your Honor, that forensic podiatry should be excluded wholesale. And the reason for that, again,
You need to say that in order for you to prevail.
Not entirely, Your Honor, because again, if you look at forensic podiatry in terms of of the sufficiency of the evidence, which I'm sure we'll get to at some point, I could still win even if you allow the testimony of Dr. Nuremberg to come in.
Well, even if we decided that we don't have to address whether, as a science categorically, if we find that this specific evidence, as he testified, was not useful to the jury, given all the exceptions and the margin of error and the other things to which he testified, do we?
I wholeheartedly agree with that statement, Your Honor. I was answering the question from the Chief Justice, but my position is twofold. Both, it could be categorically...
Sort of like saying facially or as applied.
Exactly.
Really,
So
I would argue both, but in
just
this case, we only have to find as applied.
But just to follow up on that, many courts have relied on expert testimony from forensic podiatrists, maybe not in these particular circumstances, but in other cases, haven't they?
I would not say many courts, Your Honor. I've cited in a letter to the court yesterday one case from Minnesota that excluded Dr. Nuremberg's testimony based on reliability. The state offered another case, a case from Wisconsin, where it was allowed in. Those are the only two that I'm aware of that address, and again, those are both lower court cases.
But as the questioning has progressed so far, based on the facts of a particular case, it could be reliable under one set of circumstances, but not under another.
I would argue against that proposition, Your Honor. My argument is that it is wholesale unreliable. However, we don't need to reach that conclusion because in this case, it was unreliable.
Because even if we thought, okay, the real method has sufficient substance behind it to be admitted, he couldn't use the real method in this case because he didn't have a heel. So that affects, even if we find that the science as a whole is legitimate, that the application here, it was not useful to the jury.
Correct, Your Honor. And there were multiple other problems, not just the inability to use the real method, but the sock thickness, the expert couldn't account for because he did not know the difference between the sock thickness of the sock made at the crime scene because it was never recovered and the sock thickness that was placed on Kailie when she was making her reference sample.
And the sock at the scene was saturated with blood in addition, making it another layer of complexity.
Correct, Your Honor. And also, the sock that was used for the reference sample wasn't dipped in blood. It was dipped in LCV, which is a completely different substance.
So there are lots of problems there. I want to ask you a different question. We don't usually apply harmless error to expert testimony, but I just want to look at the damage, if any, that Dr. Nuremberg did here. As you know, his opinion was, yeah, there's a moderate level of evidence to support that, maybe she made the footprints. And later he said, my opinion is she could be the maker of the footprint. I just can't rule her out. So basically he's saying, I have a technique here that I could have ruled her out. She's not ruled out, which means that she is in the entire category of the rest of the population of the world who didn't get ruled out here. Was there really any damage that came as a result of the fact that he's an expert, and he says, I'm an expert, this is subjective, this is my opinion, but I just say that I can't say that, that she was. I just can't rule her out. It's kind of de minimis, isn't it?
It's not de minimis, Your Honor, because it is literally the only thing that the state could point to that placed my client at the scene of the crime.
But it doesn't place her at the scene of the crime.
Well, it moderately does, Your Honor. And if you're...
Whatever that means.
How can you moderately be somewhere?
Moderately.
He's simply saying she could have been, along with a whole host of other people.
Well, agreed, and again, that sort of dovetails into my sufficiency argument. But when you have an expert, a quote expert, sitting up there, I don't think it's any stretch of imagination that we all know what that means when a jury...
Well, we also have the problem of the prosecutor's comments, especially in a rebuttal, when he said, what we know is that her footprints were found at the scene, which it depends on what you mean, how you define moderate, which wasn't defined, but I don't think it meant we know it. So do we look at this holistically?
Well, certainly, Your Honor, anytime you do a harmless error analysis and when you're talking about a prosecutor's closing and the statements they make, you look at a lot of things. The cumulative errors, you look at the weight or the value that you place on the state's evidence. And here, this case was rife with error.
Well, I have a standard of review question. Based on a hypothetical that nobody has to agree with, and I have the same question for the state. Assume that there was sufficient evidence at the motion in limine stage, given our deferential standard and the discretion that's allowed to the court, to admit him as an expert to give testimony. Assume at the trial more facts come out that make it clear that it's not, the expert's testimony should not be admitted. Do we treat the attempt to keep the evidence out in the motion as a continuing objection, so it's preserved, or because the defense didn't stand up and say, okay, now there's new evidence showing that the motion in limine should be changed, do we look at it under obvious error? What's our standard of review in looking at the evidence at trial versus the evidence at the motion in limine stage?
Well, part of the problem, of course, Your Honor, is the hypothetical doesn't match the facts of this case. But typically, when there's an objection made at a motion hearing, it's preserved throughout the trial. And so I would certainly say that just because defense counsel didn't jump up at every statement that, or a defense counsel, because again, this is a hypothetical, that a defense counsel doesn't jump up and say every time a misstatement is made that doesn't match testimony at a motion in limine hearing, that that's a failure to preserve it. I think that would make for an incredibly long trial if that were the case. And I think so. I would argue to you that it's a continuing objection that this court should look at under the abuse of discretion standard.
So even though it may depend on evidence that comes out at the trial, there doesn't need to be an additional objection at that stage?
Correct, because we're looking at the reliability methods, and well, I mean, those were established at the motion limine hearing, of course, but they were also testified to at the trial, and so under the continuing objection standard, I would argue that it's a standing objection.
Should we adopt the black box test for reliance as the gold standard for admission of subjective expert testimony?
Yes, you should, Your Honor. It was Dr. McCarthy testified, who, by the way, has multiple years of experience as a forensic analyst, that standard is incredibly important because that's the only way that subjective opinions can be tested.
Is the problem, go back to the language from your perspective, and since I can give myself the red light grace, I will, that the language we used in our prior cases, Searles and Bickert, et cetera, is whether any studies tendered in support of the testimony are based on facts similar to those at issue. Is that part of the problem? Is, in other words, that to the extent there's articles, et cetera, it's not really, none of it is based on facts similar to what was happening here?
I think that is part of the problem. I would argue that the Bickert case at large is an entire problem. And again, in my brief, I argued that this court should adopt the Daubert standard, which I don't have time to argue, but I think the main test is a problem on multiple fronts, but that highlights one of them.
Okay, thank you.
Thank you.
Attorney Sibley, we'd be happy to hear your argument.
Thank you, Chief Justice Stanfill, and may it please the court. On April 21st of 2022, Kailie Brackett withdrew over $700 from the bank accounts of her best friend, Kim Neptune, later telling police that she was communicating with Kim through a secret account that automatically deleted their messages. However, during the time Ms. Brackett was withdrawing the money, Kim was in fact dead, lying in a pool of blood on her bedroom floor. Nearly 500 individual sharp force wounds had been inflicted upon Kim. Hands covered in Kim's blood had searched behind her bed in the exact place that Ms. Brackett knew Kim usually kept her stash of illegal pills. And crisscrossing Kim's bedroom and the stairs leading to her up to her apartment were footprints in Kim's blood. Footprints that forensic podiatrist, Dr. Michael Nierenberg, determined to have 50 out of 60 similar features to Ms. Brackett's known footprint. The trial court committed no error by admitting Dr. Nierenberg's expert testimony. That testimony contained all the hallmarks of scientific reliability and pertained directly to a significant fact at issue: who was likely to have made the bloody footprints. In Daubert, even the U.S. Supreme Court acknowledged that what happened in this case, testing Dr. Nierenberg's opinion on cross, presenting a competing expert opinion, and instructions on the state's burden of proof are the most appropriate ways to challenge expert testimony, not wholesale exclusion. The trial court also committed no error by admitting 6 representative photographs of Kim's injuries. The photographs illustrated the medical examiner's explanation of her nearly 500 wounds and established 2 essential elements: that the conduct resulting in Kim's death was depraved, or it was intentional or knowing. Neither the truth of what happened to Kim nor the photographs depicting that truth too accurately can be ignored or hidden simply because Ms. Brackett asserts prejudice. Finally, the state did not obviously err in its closing, and the trial court did not obviously err at sentencing. The state's arguments were fairly based on the evidence presented, and the totality of the record demonstrates the goals being served at each step of the court's sentencing analysis. For these reasons, and the ones articulated in the state's brief, this court should affirm Ms. Brackett's judgment of conviction and sentence, and I'm happy to take questions at this time.
Attorney Sibley, you said that Dr. Nierenberg testified regarding I think you used the phrase, significant fact in issue. Who made the bloody footprints? I take it, maybe I'm wrong, that you would agree that if it was error to have admitted Dr. Nierenberg's testimony, you would agree that that is not harmless.
That is quite an interesting question that I was not anticipating, Your Honor. No, I wouldn't necessarily agree that it's not harmless. There was significant other evidence indicating Ms. Brackett's involvement.
I was interested to see that you yourself called it a significant fact in issue. Who made the bloody footprints? It's sort of hard to say it's not harmless after you say that.
Fair enough, Your Honor, but even if we take that out of it, there is still sufficient evidence to support Ms. Brackett's conviction, albeit far more circumstantial.
Counsel,
but this,
you didn't argue in your brief that the admission of it was harmless, right? You just argued that it was an error. Is that correct?
ultimately, yes, because it's not error in this circumstance.
So if we find it was error, have you waived any argument that the error was harmless by not addressing it in your brief?
I believe that this court could find either way, but since it has indicated waiving that or even asserting an argument in a footnote, it would be, of course, well within this court's right to find that.
Counsel, did the court, in its order on the motion to eliminate, commit clear error by concluding that forensic podiatry is recognized by a significant portion of the forensic science community, including the International Association for Identification?
No, the court did not, Your Honor. My understanding is that the IAI, or the International Association of Identification, recognized in some form forensic podiatry, I believe in 2007, and I believe that's on their website, but you have to go over to a tab to find it. But so the court did not err. The IAI has it right on their website.
And that's in the record?
I cannot recall.
Well, it's in the record that it's, there's discussion about how it's on the website, or it's been discussed. There's a dispute about whether that means they have certified or said that it is a recognized science.
Sure, and I believe they've also started a committee as well that Dr. Nirenberg chairs. Again, we're talking about a small field of science, and as Dr. Nirenberg testified, it's small because it's not, there isn't a need in the criminal realm, there isn't a high need like with DNA.
Did he reference, or were any studies produced or referenced that were based on facts similar to those in this case, i.e. a partial footprint in blood in a sock compared to somebody else's sample?
With blood specifically, I don't entirely remember, but there were several studies that he tendered in support dealing with identifying an individual from sock-clad footprints. And importantly,
Partial sock-clad footprint?
I cannot remember if it was partial.
But I mean, isn't that sort of the point, is that even if it might, and that was sort of what I was getting at with Attorney King, even if it might be valid in some situations, i.e. like a barefoot to a barefoot or a complete total prints, et cetera, that's not what we have here. We have a partial sock-clad footprint of which, there were photos, and it was removed several days later, that was had LCV on it, that he then compares to full, and even by his own testimony and by the studies and the limited information that was produced in support of this science, those are not the parameters under which the comparisons are supposed to be made.
So the comparison in this case was not simply based on photographs of the footprints at the crime scene.
Cut it out.
That was the first step, was sending Dr. Nirenberg photographs to see if a comparison was even possible. He said yes, and as part of the motion in limine, he then provided instruction to the state police how to appropriately collect samples. He had them collect samples.
I understand.
Of walking, standing, both barefoot, both sock-clad.
The problem is that it's not so much the samples. Isn't the problem that what he's starting from, what he is comparing it to, is only a partial print that did not allow the application of the one recognized real method, and that was not essentially not only not validated by black box, but wasn't even the subject of any of the other materials or peer-reviewed materials.
Well, I don't believe the blood, he has done research and did tender studies regarding sock-clad footprints. But again, his testimony hit all of the factors. His underlying hypothesis was peer-reviewed. Dr. Miller is a podiatrist and forensic podiatrist, and she peer-reviewed his analysis and his conclusion and found it reliable. So they're another expert.
Well, I want to focus on his opinion was that it was moderate, and there was some difficulty in identifying what moderate meant. He just said there's a scale that the European network uses, not in this context, but he applied it, and he said it means 1,000 times less than moderately strong, which in turn means 1,000 less time than strong. So how does that jive with the rebuttal statement of the prosecutor that we know it was her footprint?
Well, that statement is a conclusion, I believe the phrase, a position conclusion or inference supported by the evidence.
How is it supported by his statement?
What the prosecutor's statement was in reference to the 50 out of 60 similar features. And so the inference that the prosecutor was arguing based on the 50 out of 60 similarities was that we know.
But the expert himself said it's moderate, not moderately strong, not strong. So
he also said it was subjective and that somebody else could have thought differently.
He also said his opinion was that she could be the maker. I can't rule her out. Basically, he was not ruling her out, which is the opposite of saying she was the one. So we have him saying, I can't rule her out. We have the prosecutor saying, what we know is that her footprints were found at the scene. How do you reconcile those two?
Because the focus, what the prosecutor says before that is 50 out of 60 similarities. That is what Dr. Nierenberg testified to. So that statement is an inference that the state wanted the jury to draw based on that. And as far as the moderate...
So you're saying the prosecutor wanted the jury to say 50 out of 60 sounds really like it is, as opposed to just moderate?
I mean, that ultimately, that was up for the jury to determine. But even in Daubert, because I think what we're getting at with moderately is certainty.
Well, is that a sufficient level of, putting aside the reliability of forensic podiatry in general, is this statement that, well, moderately, can't rule out, could be, is that enough reliability to provide any helpfulness in terms of an expert opinion? How is that even helpful under Rule 702?
The 50 out of 60 similar
That's not
features
my question.
is...
My question is what his conclusion is.
That goes to the weight, not the admissibility.
But in order to be admissible, it has to be helpful. And if he can't provide any, I understand we don't have to phrase it in any particular way of reasonable degree of medical certainty or whatever. But how is it helpful if he can't elicit a greater amount of certainty than maybe it is, maybe it isn't?
It still is helpful in the sense that I don't think we can parse out moderate from these similar features.
Well, it's helpful if it's reliable, and I think part of the problem is that in much of the testimony that came across in this case, it's not clear that it's reliable. You even have one point that was made by the witness that was called by the defendant, suggesting that the nature of the photographs that were taken of the prints at the scene may have been thrown off scale and may have also prevented a proper comparison being made. The response to that from the state's expert was, well, I talked to the photographer and he said it was okay. How is that reliable?
Well, my reading of the motion in limine was that Dr. Nierenberg provided very specific instructions of how to take the photographs. Again, the trial court did a very good job
Well,
walking...
he didn't provide instructions for how to take photographs at the scene.
No, correct, but that was the starting point was, are the photographs from the scene even helpful to do a comparison? Dr. Nierenberg determined, yes, they were, and then provided instruction on how to collect samples in order to do a comparison. The trial court did a very good job walking through all of the factors that the law court has identified supporting reliability. Dr. Nierenberg's testimony hit all of those things, and it was ultimately up for the jury to determine what
again,
weight, if any, to give.
But
He gave an opinion. He was very frank about the fact that this is subjective. This is not a number-driven thing. You've invoked the 50 out of 60 indicia. But it's not a number case. That's a very impressive, percentage there. But even with 50 out of 60, you can't say anything more than, well, I can't rule her out. That's as strong as his evidence gets. And then we have the prosecutor's statement, which really amplifies that, which basically we've got a witness making a subjective call, hasn't been black box tested, and with 50 out of 60 indicia, he can only say it doesn't rule it out. And then prosecutor putting the icing on the cake, saying, what we know is that her footprint was there.
I saw the red light was on.
It was a blank. You can go.
Yeah, it was a fake.
It's yellow.
You still got 40 seconds.
As the U.S. Supreme Court pointed out in Daubert, it would be unreasonable to say that scientific testimony, that there's any certainty to it. Arguably, there are no certainties in science. So just because he couldn't definitively say, yes, this is the person who did it, yes, this is directly the person.
But doesn't there have to be some level of at least probability? I mean, he doesn't even seem to say that.
How is that helpful to the jury to say, I can't rule her out?
50 out of 60, it was up for the jury to say whether that was enough or not. Thank you, Your Honors.
Attorney King, I understand you've reserved 3 minutes for rebuttal. We'd be happy to hear from you.
Thank you, Your Honor. I'd like to start with the 702 issue with regard to a moderate level of support. If you look at the federal rule in comparison to our rule, the federal rule requires that it's more likely or not. So there's a threshold level that's required in order to have testimony admitted that will assist the trier of fact. Now here, Dr. Nuremberg couldn't even define what moderate means. Moderate generally means average. So
you're agreeing, in other words, that it's not helpful to the jury, given what he's saying.
it's entirely not helpful to the jury, Your Honor.
Before you even get to that point, though, before you even get to that issue in 702, Williams, Bickert, and Searle all say you have to look at certain factors to determine whether the evidence is reliable. Opposing counsel says the trial court in its decision went through those factors. Do you agree with that?
I agree that the trial court went through some of the factors, Your Honor.
Which factors did it go through?
Well, the trial court went through the qualifications.
Well, put qualifications aside. I'm talking about reliability.
That's part of one of the factors, though, Your Honor, for under Bickert is the expert's qualifications. And so the trial court went through studies with similar facts. He said that there were a number of studies that were factually similar, ignoring entirely that there were also a number of studies that were cited that were completely
Were there studies that were
dissimilar.
factually similar with a partial sock-clad bloody print compared?
It's my understanding that none of them addressed bloody imprints left. They were studies that were done as studies are done in a lab, and they were done with various substrates, but not
Can we
blood.
tell-
And so that's a problem.
Sorry, can we tell from the record whether the trial court actually reviewed the substance of the studies as opposed to just taking the expert's word for it? And is that necessary? How deep a dive does the trial court need to do in sort of verifying what the expert is saying?
Well, I think it is necessary, Your Honor. You can't, I mean, when you have two competing experts that talk about some studies say this and some studies say that, I think it is incumbent on the trial court to look at the studies and see how similar they are if they're going to make a finding that in fact they are similar.
And was that done in this case?
It does not appear that it was done in this case, Your Honor. At no point does the trial court go through any of the studies and say the Kennedy study found this or the Laskowski study addressed these factors, because if it did, the court would have found that those two studies in particular were talking about bare feet and not sock-clad imprints. And so there was a statistic that Dr. Nuremberg cited from the Kennedy study that 1 in 1.27 billion cases footprints are unique. But that study, again, was a bare footprint, which is similar to a bare handprint and has nothing whatsoever to do with a sock print.
Thank you.
Thank you, Your Honor.
Thank you, counsel. Thank you for your arguments here this morning. And as is our usual practice, we will be taking the matter under advisement. We will issue a written decision rather than issuing a decision here today in due course. With that, we will be in recess for the morning.